Mr. Deputy Speaker, I thank the members for contributing to this debate and also for sharing in our vision that access to justice must be a cornerstone of our legal system. And I also thank the very many volunteer lawyers, pro bono lawyers, like Mr. Murali, who is an assigned solicitor for LAB, because these people, apart from the rules and regulations that we make, these lawyers, with their pro bono work, contribute to the richness of making justice accessible to even the most disadvantaged in Singapore. Now, there are several queries on the bill, and I would like to jump straight into addressing them. Mr. Gantiampo asked about the number of legal aid applications. In the past 10 years, Legal Aid Bureau has received a total of 97,100, approximately, applications. Of these, 88,800, or more than 90%, passed the preliminary means test. In general, applicants who were unsuccessful had failed the eligibility criteria because they exceeded the disposable income or capital assets limit. Around half of LAB's cases concern matrimonial matters. Other common cases concern the enforcement of court orders, monetary disputes, and also probate. Let me address now the questions about the new means criteria and the limits. Mr. Henry Kwek asked about the assessment, while Mr. Chris D'Souza and Mr. Murali asked about the qualifying limits and how they will be set. Mr. Gan asked whether CPF monies will be included in the assessment of the applicant's savings and investment. And Mr. Murali also asked whether contributions would be, the CPF contributions would be included in the assessment of the applicant's income. Finally, Mr. Murali asked if there's a need for additional resources to be provided to MinLaw to administer the new means criteria. MinLaw will adopt the PCHI and the annual value of the applicant's place of residence, savings, and investments as the new criteria to replace the current disposable income and current disposable capital criteria. The new criteria are simpler and much more aligned with what we commonly use by or in current social support schemes. The new means criteria considers the applicant's gross income and assets instead of his disposable income and disposable capital. We will incorporate most of the permitted deductibles within the current means criteria, such as CPF contributions, when setting the new income limits in the new assessment criteria, to minimize the risk that those applicants who were previously eligible when we would no longer be eligible when we move from disposable income to the gross income. We will not include the applicant's CPF monies in the computation of the applicant's savings and investment. This is also consistent with our existing means test. The qualifying limit for the new means criteria will be set later in subsidiary legislation, as I said earlier, to take into account the 2018 income data, but it will be set at a level where there will be no material impact on the number of households who will remain eligible for the legal aid, and it will be set at a level which will ensure that a similar level of households at present, which is approximately 25%, will be maintained. Next, we do not anticipate at this point in time a significant spike in the number of cases that come forward, and hence my point earlier about the allocation of government resources. So it will be managed. My ministry will allocate the appropriate resources to deal with any increased caseload as may arise. But bear in mind also that the amendments do provide for specialist legal executives to come on board to lend to the giving of advice and also to appear in some of these cases. So that will also ease the load on the existing LAB. Mr. Gan asked if the use of household income would disadvantage applicants who need to support family members staying in a different household. In other words, what Mr. Gan, you're saying is, if I look at only the household income of this individual, it may not give me a full picture because he may be supporting a family member residing in a different household. We do not consider family members living in a different household in calculating a PCHI, because family relationships can be complex and diverse. The situation that Mr. Gan cited could well work the other way, where an applicant could be supported by a family member not living in the same household. In other words, he's coming to apply based on his PCHI, he would qualify, but yet he's also being supported by a member living outside of his household. The government is not privy to the family dynamics in its situation, and so it's best at this stage to use the household income as the best proxy for family support. Furthermore, this would also be more convenient for applicants, as they would not have to provide information on family members that may not live with them, and the extent of that support, and the extent of that familial relationship, and why that may be so as well. So at present, we keep to using the household income. Now, given this, we will adopt the per capita household income, as I said, although I would stress that in appropriate cases, we would also be able to consider the scenario that Mr. Gan mentioned, where it is just and proper to do so. And that is precisely the reason for the framework that we are building into the new amendments, where it is, if it is just and proper, then the minister may, in the discretion, allow aid to be granted. And so if, to take the example a bit further, if the applicant is the sole source of support for that family member, and the family member is not a beneficiary of other government schemes, those are factors that can be taken into account. Mr. Louis Ng had asked whether the ministry is tackling the legal costs and the proportion of households for whom legal representation remains accessible, and whether we would consider increasing the coverage for civil legal aid. Ms. Rahayu also asked if there could be adjustments to the limit to allow more to qualify for legal aid. I would assure members that MinLaw regularly reviews the means test for civil legal aid, taking into account legal costs, the cost of living, and other factors to ensure that legal aid remains accessible to Singapore citizens and also permanent residents of limited means who cannot afford their own lawyers. Legal aid is targeted and given only to those with limited means, as it has to be, because we have limited resources and we need to be prudent about how we allocate them. In the most recent review leading up to this bill, we had taken into account these factors in deciding to retain the coverage at the present levels. And as I mentioned earlier, at this level, approximately 25% of households are covered. Mr. Gan asked if we could consider negative net worth as part of the means assessment if the applicant's debt liabilities exceed his assets. And Mr. Murali also asked on a related note if we could consider circumstances where families are put into significant expense as a result of intervening events. We do not generally include, or rather exclude, liabilities such as the debts when we assess an applicant's means. And I think what Mr. Gan has in mind is if you are servicing or taken out a loan which is maybe secured, and where the security value may be below the value of the loan that has been taken, whether that can be taken into account. And the reason we don't do that is because the applicant may have secured debt liabilities, for example, a mortgage or a car loan, which is quite common, but may still possess savings or income above the means limit. And this may then allow him to afford legal fees. He would not be considered in that situation a person of limited means. However, if that person or the applicant has liquidated his savings and investments to pay off the debts and thereafter remains in a financial situation as would allow him to come within the means criteria, then yes, that person will be considered for assistance. We will also consider an indebted individual with extenuating circumstances on a case-by-case basis and may grant aid where it is just and proper to do so. So, for example, if the debt was incurred due to the significant expense as a result of an intervening event, as Mr. Murali puts it, for example, a serious acute medical condition, then yes, those are circumstances that will be taken into account as well in the assessment. At the same time, whilst we are not expanding the coverage or considering the negative net worth and family members living in a different household when assessing means, the bill, as I said earlier, does provide for greater flexibility and discretion for aid to be granted to deserving applicants. And this will allow us to provide aid in a more targeted manner, which would also achieve greater equity. Now, this brings me to the questions from Mr. D'Souza, Mr. Henry Quek, and Mr. Murali, who asked how this flexibility could be exercised. Mr. Murali asked in particular, what are the circumstances in which it will be just and proper to grant aid? I think I've given a sense of what that might be in my earlier paragraph. Ms. Rahayu also asked if we can consider extenuating circumstances, for example, children or relatives staying in the same household but not contributing to the household income, or applicants who stay in private properties due to their circumstances in our computation of the PCHI or annual value. The intention behind the amendments and the regime that we've set in place in this bill is, of course, to allow for more flexible assessment to be made in order that aid can be granted if the minister is of the opinion that it will be just and proper to do so. The key words being just and proper. And we want to retain that flexibility on a case-by-case basis because each case will be different. The circumstances that present for each applicant will be different, and we want to have the flexibility to be able to assess these factors on a case-by-case basis. When such cases arise, the minister may authorize any person, and that includes a panel of persons suitably qualified, to make that assessment. In exercising the discretion, we may consider granting aid to an applicant who might otherwise fail the means criteria, but still not be able to afford legal services due to extenuating circumstances, those that we mentioned. Mr. Murli gave some examples, and Ms. Rahayu as well. We will also consider if family members staying in the same household cannot contribute to the individual's legal costs. So, for example, children is one example, but the other would be where the family members living in the same household may be estranged from each other. I just don't want to be taken in my answer to be limiting the circumstances in which we consider that. So I do stress that it's on a case-by-case basis and looking at the particular facts of each case as they present. Applicants who fail the means criteria will be informed of the reason. Applicants who may then have extenuating circumstances can bring this up to the minister under the procedure. It is not a statutory appeal, but at this point in time we are working out the operational details and also the procedural steps necessary for this to be highlighted, but it will not be treated as a statutory appeal. Mr. Gan asked if the ministry can consider alternative sources of assistance to applicants who do not qualify for legal aid. In other words, persons who fail the means test, and the example Mr. Gan gave was to ask solicitors to afford or to grant a deferred payment scheme for legal fees. Now, government assistance is generally given to those most vulnerable and those in need of assistance. And that's what the current regime for means criteria seeks to achieve. If an applicant satisfies this criteria, plus the merits test, he'll be given legal aid. But if the applicant does not satisfy the criteria, but goes on nonetheless to engage a lawyer, we will be unable to mandate that there be a deferment payment scheme for such services, which are really between the individual as the client and his solicitor. But this, not being able to do it by legislation, does not stop a client from requesting his lawyers to consider either an installment scheme or a deferred payment scheme as may be appropriate. Next, we will also be making various improvements to the administration of legal aid. And Mr. D'Souza asked for the elaboration of the rigorous training that public officers who are not qualified persons under the Legal Profession Act will undergo in order to appear and plead in court for an aided person. Mr. Henry Quek asked if MinLaw would decide what cases these public officers would take on and whether this would compromise the interests of aided persons. The Legal Aid Bureau will ensure the thorough and proper training of such persons and will ensure that no aided person's interests will be compromised as a result of the use of such public officers. The LAB's legal executives are well trained and they do complement the work of the legal officers. Currently, legal executives already perform a significant amount of work at LAB, and this includes taking of instructions, preparing drafts of certain documents, and we feel that many of them are capable of doing more and can be made to do more. So we'll allow our best legal executives to be appointed by the director to provide legal advice and also represent applicants in court proceedings and at mediation. All appointed specialist legal executives will have to attend legal knowledge courses on subject areas, relevant subject areas to the kind of work that they do. So it'll be in the areas of divorce, mediation, the Singapore legal system, professional skills, and of course legal writing. These courses will be provided by both external providers as well as through the in-house legal expertise which already exists at LAB. They will have to go through a practical training program which will cover skills such as drafting, client management, client-facing work, court etiquette, and so on. They will be accompanied by in-house supervision by experienced legal officers and assessments made before they are allowed to attend court and represent clients. This training will ensure that the specialist legal executives will be well equipped to handle the expanded scope of work so that LAB's clients' interests will be effectively represented. Now, even then, for a start, we intend to limit the cases where such officers will take up to simpler, uncontested divorce proceedings where the matrimonial assets are $1 million or less as a starting point. If the matters that these officers are handling becomes subsequently contested or more challenging, they will be handed over to a lawyer who will take over the matter. We will continually review the role of the specialist legal executives to consider what more they can do. This will no doubt ease the burden and bring down costs overall, as well as allowing for cases to be managed more expeditiously, as I mentioned earlier. Mr. Quek asked about the rationale for allowing the director, instead of the legal aid board, to grant aid for straightforward matters. Mr. Quek asked if we could avoid the director being a bottleneck. Currently, at this point in time, the merits of all applications are assessed by the legal aid board, which comprises the legal aid director and not fewer than 2 solicitors from a panel of solicitors maintained under the Act, and the board meets once fortnightly. This means that after LAB has prepared a legal opinion for an applicant, the applicant may have to wait for up to 2 weeks before aid is granted or deferred or refused. Allowing the director in such cases to grant aid for straightforward matters will help and not hinder the applicant's case by up to 2 weeks, as the director can now immediately determine whether, in that case, aid should be granted or not, assuming the means criteria is satisfied, without waiting for the board to convene. This discretion, however, will only be exercised in straightforward matters, such as uncontested matters relating to probate, letters of administration, guardianship matters where the defendants consent to the proceedings. Any application for which aid may be refused will still go through the legal aid board. Let me just wrap up with a few of the other clarifications that members have raised. Mr. Quek asked whether permanent residents would be subject to a more stringent set of criteria in our assessment on whether they qualify for civil legal aid. The criteria will be the same, but permanent residents will generally be charged a higher contribution towards the cost incurred for their case if they are granted legal aid. Mr. Lewism asked why aided persons have to go through fresh means tests when appealing a decision for a case in which aid was previously granted, and for a case where the aided person subsequently wishes to enforce the judgment. Mr. Ng also asked whether the Minister would consider an expedited process for assessing whether to extend aid to an aided person who wishes to file an appeal, given that strict timelines do apply in the context of when an appeal is brought. We require aided persons to go through a fresh means and merits test because considerable time may have elapsed between the time that a person first applied for legal aid and was granted and the completion of his initial matter. The means may have changed during this period of time. And as Mr. Ng also acknowledged, the merits may also have changed given that the proceedings have taken place, evidence may have been led, and a judgment may have been issued in this case. So a fresh merits test is also necessary to ensure that we continue to grant aid only to those most deserving, and this includes those that are applying or seeking a meritorious outcome. And this includes for an appeal. No doubt when a second merits test is involved, where one is making an assessment on the same matter, but given the lapse of time, the time taken for that assessment will no doubt be quicker. Circumstances in such a case, however, which may affect the merits of bringing or resisting an appeal or in enforcing a judgment may have changed, and it will be useful to have regard to this in the fresh merits evaluation to ensure that the grant of aid still remains appropriate. I would also like to assure the member that where an applicant requires aid as a matter of urgency, for example, when an appeal is due to be filed, the director may issue a grant of aid on a provisional basis if the director is of the view that the applicant is likely to satisfy the means test and is likely to have a reasonable ground for appealing against the decision. This grant is typically valid for a period of 3 months and can be further extended if necessary. Under the provisional grant of aid, the Bureau may assist the aided person with the filing of the notice of appeal. In addition, the Director can also issue a notification under Section 17 of the Legal Aid and Advice Act to stay the proceedings for a period of 14 days whilst this is being done. Mr. Murali asked if the Ministry has considered Mr. Hari Kumar's suggestion back in 2013 for the government to introduce a public defender. It's getting late in the day. Public defender scheme to help indigent citizens who face criminal proceedings. Since 2015, the government has provided close to $6 million funding support to the Law Society pro bono services, which run the criminal legal aid scheme. CLAS, in turn, assigns lawyers to accused persons who have been charged with a crime and cannot afford hiring a lawyer. So in this way, this has resulted in an expanded assistance to criminal defense cases, as CLAS has been able to assist almost 4 times as many applicants in 2017 compared to pre-2015, before the funding was made available. Mr. Ershad asked if we can equip micro enterprises with the legal resources such as business contract templates. This would no doubt simplify process and the way in which legal services may be delivered on simple matters, but it's probably more appropriate for the Law Society to take this on, and we will consult with the Law Society Pro Bono Service Office and other volunteer groups to consider if they can provide the micro enterprises with such assistance. I will end off by highlighting the holistic help. Some members have asked about it, in particular Mr. Patrick Tay, that LAB and his partners have been giving to legal aid recipients who have more than just legal needs. This addresses Mr. Tay's questions about giving help to families in need, and also to Mr. Ershad's questions on public education and what more could be done to bring awareness of these schemes to the public's attention. Members would know that the Ministry works with partners such as the Law Society and the Community Justice Centre to raise awareness of the law and avenues of legal help. For example, through pamphlets that are produced, and also the annual Law Awareness Weeks. The Law Awareness Weeks, which just took place a few weeks ago, has expanded from one which lasts just one afternoon on one weekend to one that lasts 6 weeks, and it is held at various locations across Singapore. And this helps to bring awareness of the offerings that pro bono lawyers working with Law Society can offer to the community. Since 2016, LAB has also established referral protocols for family violence victims with PAVE and with the Ministry of Social and Family Development for those with social service needs such as housing problems, family dysfunction, and also addiction issues. LAB is working with other agencies such as Big Love and Hearts at Fei for applicants with child protection issues. The referral protocols allow LAB to refer applicants who refer other social services to these agencies for help. Conversely, the agencies may refer applicants who require legal services to LAB for legal help as well. So it works both ways. The referrals have helped a number of individuals, and I'd just like to highlight a few examples. For one such referral, the applicant had applied for aid for his divorce proceedings. His wife was verbally and physically abusive to the family on a daily basis, which had a negative impact on the children. LAB, when they came to know about this, referred the case to PAVE, worked with PAVE to make arrangements to assign a social worker to the applicant and also to give counseling to him and his family. In another case, an 80-year-old applicant had a personal protection order, or a PPO, and a partial domestic exclusion order against his adult son, who was violent to him. And this allowed the son to occupy only one room of the flat. However, his son continued to use violence against him, and during one quarrel, his son pushed him on his chest, causing him to hit his back and fracture his rib. LAB was aware of this and immediately referred him to PAVE, a family violence, as you know, family violence specialist agency, worked with a nearby senior activity center near the applicant's flat in a community to set up a community watch for this individual. PAVE then subsequently also worked with LAB to support the applicant through the court process. LAB eventually successfully obtained the full domestic exclusion order for the applicant. Where relevant, LAB proactively assists vulnerable victims and applicants to protect their legal rights. For example, if the applicant applies only for assistance in divorce proceedings, but when they come to LAB and LAB officers detects that there might also be family violence involved, then LAB will consider if it would be appropriate for him or her to also commence PPO proceedings or other such measures and assist with those applications. If the order involves the maintenance of wife and children, we will also inform the applicant how he or she can enforce the order if the other party does not comply with the order. So I hope I've dealt with all the queries that have been raised. I'd just like to make a few remarks in conclusion. First, to thank the members' support for the bill. The bill will allow the LAB to continue its good work. As you know, it is in its 60th year this year, shortly after the setting up of this legal LAB back many years ago. LAB's work is simplified by simplifying the means criteria, which makes the process quicker, easier, and also fairer. Second, it provides for more flexibility for aid to be given for those who might fail the means criteria, but nonetheless still can't afford legal services for a number of reasons. And finally, improve the overall administration of legal aid. This is part and parcel of MINLAW's efforts to ensure that legal representation remains accessible for the general public, and in particular, the most vulnerable of persons. But beyond legal aid, MINLAW is also committed to ensuring that the legal process is made simple and that access to justice in other forms will be enhanced. So we enhanced the family justice system, which centers on the welfare of the child and the family through the Family Justice Review Committee, established with the MSF and the courts. Second, we are also looking at substantive reforms in civil law to keep legal costs affordable, to reduce the complexity of civil proceedings, and strengthen the enforcement of civil judgments. Finally, we also enhance frameworks that enable Singaporeans to resolve their disputes quickly and cost-effectively, and where possible, as amicably as possibly can in the circumstances. So we have built up the infrastructure for mediation to take place. Community mediation has been happening for a while, and we have also raised the claims limit recently for the small claims tribunal from 10,000 to 20,000, so as to allow more to benefit from this quick and relatively inexpensive forum. Finally, as I said at the outset, I reiterate, I want to take the opportunity to acknowledge the various contributions from so many community partners and the legal fraternity, including the assigned lawyers and volunteer lawyers, all of whom have made LAB's work more rich and more satisfying in the last 60 years. We thank them for their continued support, and will continue to work closely with the legal fraternity to provide access to justice to persons with limited means through pro bono efforts or low bono efforts, and assess how we may better recognize lawyers for these efforts, as Ms. Rahayu has suggested. Thank you. Sir, I beg to move.
The question is that the bill be now read a second time. As many as are of the opinion, say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Legal Aid and Advice Amendment Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion, say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 23 stand part of the bill. As many as are of that opinion, say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in Parliament and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion, say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Legal Aid and Advice Amendment Bill.